morning. Thank you, Dr. Lee, for the introduction, and Dr. Antevi for organizing this. And I just want to quickly say that in Greater Broward, you guys really have a very active, very engaged group of medical directors, and it's great to see. This is really a kind of a refreshing interaction between medical directors and the EMS community, and it's great to see. And I'm happy to be invited and very happy to be presenting. So let me just pick up where Dr. Lee left off, and I do really just like to emphasize the part of my background that comes from EMS. It's really all I've done. I started out as a volunteer EMS provider in central Pennsylvania when I was a kid, pretty literally, and became an EMT at 16, and then I worked in some paid EMS positions, and also then became a county EMS director and a regional EMS director, worked at our state EMS council, and then I worked in Washington for a while before law school at the U.S. Department of Health and Human Services doing EMS and trauma care planning around the country. Then I went to law school, so this is kind of the second career, and all that our firm does is represent EMS agencies and EMS providers. We don't sue them, we defend them, and that is our sole client base, and there's about 16 or 17 of us in the firm now, so we've grown into a nice little enterprise here that's solely dedicated to this industry. So those are just the pieces of my background I want to emphasize, but primarily the EMS field background and the EMS management and administrative background as well. Let me jump into our subject matter here. Of course, a couple of quick legal announcements. Wouldn't be a legal seminar unless we did that. I love this one. Am I searching for the truth? Don't be silly. I'm a lawyer. These slides are just to remind you that all this stuff is copyrighted, and if you're going to steal crap, do not do it from a lawyer. And this is just a reminder that we do welcome questions, and Dr. Lee told you that you could type those in the chat box. We'll look forward to taking some questions before we're done. But just remember, if you've got any sort of sensitive information, that this is not an attorney-client privileged consultation. Don't disclose anything that you don't want the world to know about, because there's no attorney-client privilege by asking me a question in a seminar. That's all we have to remind you of. So let's jump into the title of the webinar today deals with depositions, but there's a broad range of circumstances actually in which medics and EMTs and other EMS providers might have to testify. And a deposition is part of what we call discovery, and you're most likely to have to testify in the discovery phase of a case. And we'll talk about discovery and what that is in a minute. You might also have to testify in a hearing, which is not quite a trial, but it might be done by video, by telephone, it might be done in person. There's different kinds of hearings, and we'll talk about those in a second. Or it might be a trial, an actual civil or criminal trial. So those proceedings can be either administrative, civil, or criminal, and it's important to remember that when you're testifying or giving a deposition, it's not always, a civil case, for example. There are depositions that can be taken in an administrative case. For instance, if the State Department of Health proceeds against a paramedic, say, for revocation of their license because they are alleged to have engaged in an unprofessional act or something along those lines. Excuse me. There might be witnesses who would testify one way or another about the medic's good character and good reputation and why you shouldn't take his or her license away. There might be fact witnesses that will say, yeah, a person did something bad and here's why you should take their license. So it might not be a lawsuit, but it might be still under oath testimony in an administrative type of proceeding. Of course, civil cases are somebody sues somebody else. An accident, for example, a motor vehicle collision where you're a provider, one party is suing the other. You're not involved in the case as a party, but you're a witness as to injuries or treatment provided, something along those lines. Or a criminal case. For instance, you treated a victim of a crime or a defendant or a suspect in a crime. Did he make any statements? What was his demeanor? What did he, what were his injuries? Those kinds of proceedings can involve testimony as well, usually more at the trial level as opposed to depositions, but can also be in a depo. So let's talk about what a deposition is here for a second. A deposition is usually testimony that is given during what we call a discovery phase of a case. And discovery is exactly what you think it is. It's exactly what the name implies. It's so each side can find out what the strengths and weaknesses of their case and the other side's case are, and we'll talk about that in a moment. It's not the only discovery method that lawyers use, but it's the one that we're going to talk about today. If I'm trying to flesh out the other side's case, I'm also going to send the other side requests for documents. For instance, if a plaintiff sues an EMS agency for, say, medical malpractice, I'm going to request a whole bunch of documents from the plaintiff. I want to know what their wages are, where they work, how much they earn, because they're going to make damage claims. I want to know if they were injured in any other way, if there's any other causes of their injury. So I'm going to ask them for a whole bunch of documents. They're going to ask you for a whole bunch of documents. They're going to want your patient care report. They might ask for an incident report, although we might object to having that produced because we might claim that it's privileged. They might want your employment records. They might want a whole bunch of other documents. They're also going to send you what are called written interrogatories. These are questions that you would answer in conjunction with your lawyer that are in writing as opposed to verbal. So there are 3 or 4 different discovery methods that lawyers will use. Depositions are simply one of those that occur in the discovery phase of the case. By the way, that can go on for years. The discovery phase of a case can go on, for a long time. And the importance, and although today is not a documentation seminar, we do an awful lot of training on documentation, but it emphasizes the importance of good documentation because there could be a period of years that go by between the date of an incident and the date you're testifying about the incident. And if you don't have a good and thorough patient care report, it's very difficult for you to tell the story that you need to tell when you can't recall the details. In my experience, it's not we all have calls that are burned into our brain that we'll remember forever. I know I do. But it's typically the calls that don't stand out in your mind that you might be likely to end up in court. So having a good, thorough, solid, and defensible patient care report is really critical when you're trying to tell that story. So let's talk about some of the logistics. I mean, where is a deposition taken? Well, most often it's taken at somebody's office or in a conference room. It's not usually in court. That's where you testify at a trial or a hearing. But the deposition is usually taken at a lawyer's office. They might come to your workplace and do it there, maybe an empty conference room in a courthouse. But don't let the setting fool you. Even if it's a familiar setting, even if it's at your station, even if it's in your lawyer's office or some nondescript conference room, depositions are still testimony under oath. Generally, the court reporter, the person who's taking down all the testimony on one of those little stenography machines, is also authorized to administer oaths. And when you testify in a deposition, it is as if you are sitting in a courtroom with your testimony being under penalties of perjury. You don't get to lie in a deposition even though it's not in a formal courtroom. So don't let the informal setting fool you. So the purposes of a deposition, there's a number of them. One, of course, is the parties want to learn the facts of the case. I need to know what happened. Both parties need to know what happened. Secondly, the lawyers, the purpose of discovery is hopefully to promote settlement. Judges don't like it when cases go to trial. It takes up time. There's a lot of cases. And judges really lean on the parties to settle cases. So discovery and depositions allow us to assess, hey, is our case as strong as we think it is, or is the other guy's case as strong as, stronger than we thought it was, or is our case maybe weaker because of what witnesses are saying? So if we can assess really what the true value of the case is, it's more likely to promote settlement without having to submit the factual disputes to a jury. A deposition might also help us identify who other witnesses are. Well, who was there when that happened? Can you identify the other, so that way we can determine who else we need to depose. We can determine if any additional parties need to be brought into a suit. If we determine that somebody, through their testimony, committed an act of negligence that we were previously unaware about, well, we may end up naming them as a defendant. And probably most importantly, we want to lock a witness into their story and use that testimony because it is under oath, it is all written down, it's all transcribed word for word, and if you say something different at the time of trial than what you said at your deposition, I can use your under oath sworn testimony from your deposition to do what we call impeachment, which means I can use it at trial to say, yeah, but 6 months ago or a year ago when you gave your deposition, you said X and now you're saying Y. And that can impeach the credibility of a witness and really damage their credibility in front of a jury. So you want to make sure your story is consistent. The part about locking in a witness to their testimony, I always use this example, and we've probably all seen this movie. These are shots from the movie A Few Good Men, and it's, of course, drama, and everything's over-dramatized in the movie. And I love this, everybody loves the climactic scene where Tom Cruise's character is questioning Colonel Jessup, Jack Nicholson's character, on the stand, and there's the whole "you can't handle the truth" and all that. And remember where we're at in the movie, right? The key witness has died. He committed suicide. They don't have any good evidence, and their only strategy is he's going to try to piss off this hot-headed colonel to the point where he blurts out a confession that saves the clients, right? "Did you order the code red of Private Santiago?" And Nicholson says, "You're damn right I did," right? And we all remember that scene, and then the great look on Tom Cruise's face where he just looks stunned that he can't believe he got the witness to blurt out that admission. Great drama, but it's never going to happen in a courtroom because I already know what you're going to say in response to that question. It's not a high moment of drama. It's really staged theater because every witness who's on the stand, we've already taken their deposition, and I know what you're going to say. And if you're likely to fudge your story or even lie about it, I know where you're probably going to do that because in your deposition, I've already gotten your testimony, and if there's something you said in your deposition that hurts your case, you might try to walk that back in your testimony in court. I've already got it locked in by your deposition. So keep that in mind. Now, if you're subpoenaed or asked to give a deposition, it does not mean you're in trouble. Usually, in fact, you're not a party to the lawsuit. You're merely a fact witness. You saw, you heard, you observed, you know things that happened that are important to the parties. Say it's a simple vehicle accident. One party ran a red light, T-boned another driver. They're trying to prove the injuries and the liability on the other side. You would have direct testimony, direct evidence through your observation and your actions of what the injuries were, what statements may have been made. Those are important facts. Doesn't mean you did anything wrong. It simply means that you have facts that the parties need to know. However, let's say it's a simple case of somebody running a red light and T-boning the other driver. Well, that driver who runs the red light is negligent and they're liable. But what if a medical provider also committed an act of negligence that also harmed the patient? There can be more than one cause of a plaintiff's injury. So if you make an admission, well, yeah, I screwed up the intubation, or yeah, I didn't properly immobilize the patient's cervical spine, but it was the driver of the car that caused those injuries, not me. Guess what? You've just invited yourself to the lawsuit now. Evidence that's brought out in a deposition could lead to a party being named in the lawsuit. Usually, however, that is not the case. You're simply a fact witness. So that said, let me just grab a sip of water here. And let me also just reiterate the reminder here that that Dr. Lee mentioned. If you've got some questions as we're going through, please type them in, and he'll moderate those Q&A questions at the end of our presentation. A couple of quick tips on testifying here. First and foremost, I know this is easier said than done. Some of you listening may have had experience as a witness or even as a defendant, and it can be a very intimidating process, being in a courtroom, being in a lawyer's office, whatever it might be. But try not to be intimidated. You're there because you have knowledge that the parties need to know. It's usually not an exercise in trick questions. Usually we just need to get the facts out on the table. Now, your testimony may be compelled by a subpoena. In fact, because of HIPAA and privacy concerns, you shouldn't just voluntarily go and testify whenever it involves disclosing patient information. We typically require, and most lawyers know, they're going to need a subpoena to get you to be able to share patient information. If you receive a subpoena at home, at your personal address, or wherever it is you get your mail, or somebody walks up and hands it to you, make sure your agency knows about it, because they may have the obligation or the ability to get legal counsel involved, make sure all the I's are dotted and the T's are crossed. It doesn't usually mean you're the one being sued. But again, make sure your agency is aware if you've received a subpoena. Because remember, it's their protected health information. They're the ones, your agency is the one that has the obligation to preserve and protect the confidentiality of that information. So make sure they're in that loop. Some subpoenas are only for records. You have to read them carefully. Some subpoenas require you to show up and actually testify. So make sure that you or your agency or their legal counsel carefully reviews the subpoena to determine what type of testimony or documents are being sought. Oftentimes when somebody's only looking for documents, it'll be called a subpoena ducis tecum. Other times it'll just say subpoena. Either way, it's not always very clear and easy to be able to tell what it is they're looking for. And sometimes subpoenas are overbroad. Say, for instance, a lawyer subpoenas patient care records and incident reports. Well, under the law, the incident report may be protected. A lawyer may ask for it. It doesn't mean they're entitled to it. The lesson is, don't just look at a subpoena and say, oh, okay, I'll give them what they ask for. Subpoenas can be objected to by lawyers as well. So make sure your agency knows about the subpoena, and they may have an opportunity to object if that subpoena is overbroad. As I said before, all testimony, whether it is a deposition, a hearing, a trial, or anything else, excuse me, is under oath. Therefore, your responses need to be truthful. If nothing else, the truth is always the easiest thing to remember. You don't have to worry about impeaching your own testimony if you're consistent and if your responses are truthful. Now, if you're subpoenaed or asked to testify, you're allowed to prepare. It's okay to review your patient care report. If you're going to testify at a trial, it's okay to review your deposition that you may have given. Remember, that may have been a year or two before the hearing or the trial. It's okay to review other documents. In fact, it might be a good idea to do those things. What we don't recommend, however, is that you get together with other witnesses to get your story straight. When witnesses collude and they get together and decide what they're going to say and how they're going to word it and how they're going to testify, that's never good when it comes to your credibility. So you can prepare, you can brush up, you can re-review your testimony from your deposition, you can review documents, talk to your legal counsel or whatever lawyer your agency makes available for you. They'll give you a lot of good advice, but don't generally sit down with other witnesses and talk about, let's all say this, right? If it's a hearing or a trial and you've already given a deposition, remember that that prior deposition you gave is under oath, was under oath, and if you say something at the trial or the hearing that is different, even slightly, or inconsistent from what you testified to in your deposition, that testimony can and will be used to impeach what you're saying now, and that's going to undermine your credibility, and the opposing lawyer wants to do that. They want to impair your credibility, and you don't want to give the opposing side that easy of a shot at you. Some other tips on preparing. Don't memorize your testimony. If it looks rehearsed and over-prepared, the first thing a jury is going to think, and we always make jokes about juries as lawyers, we say that when you go to court, you put your fate in the hands of 12 people who weren't smart enough to get out of jury duty. But look, jurors have a good sense of what's right and wrong, and they read people and witnesses pretty well. Testimony that looks over-rehearsed or over-prepared can make it look like somebody's pulling your strings and telling you what to say. Talking in a direct, conversational manner is preferable to than trying to recall and recite something that you've memorized. If you're in court, if it's a hearing or a trial, try to get a look at the courtroom before you go in. Where do I walk? Where do I sit? Where do I go? So you don't look, confused and you're sort of walking in circles, and all of those nonverbal cues can lead a jury to make judgments about credibility. It allows you to confidently approach the witness stand, take your seat, and give your testimony. What do I wear? Well, there's always a debate. If you talk to, lawyers all over the country, they may say, well, we want you to wear your uniform. Others may say, dress like you're going to church. Well, some people, I guess that means pajamas, right? We worship at St. Mattress on Sundays, some of us, but generally, business attire is preferable. I personally am not a big fan of uniforms on the witness stand. Other lawyers do want you to be in uniform. The lawyer that's going to put you on the stand, or your attorney will give you advice on that. But generally, you're going to want to look professional. It's not a blue jeans kind of day. For a deposition, fine. I don't really care what you wear for a deposition. But for testimony in court or in a hearing where there's a judge or a jury or both, you've got to be in business attire. You've got to look professional. There's even studies about that show that black is good for men, blue is good for women in terms of credibility and believability. It's hard to imagine, but there are people who make their living off of those kinds of details. Avoid making statements. It's not a fashion statement. It's not a fashion show. No flashy, gaudy jewelry. I sent a witness home once, a nurse, because she was wearing flip-flops. And she had a tendency to just, the way she crossed her legs, her foot was kind of dangling at the level of the jury box. And when we took a break, I sent her home and had her put closed-toe shoes on. I mean, it's just, there are little things that can be distracting. And it's not a time to make a fashion statement. No flashy, gaudy jewelry. No buttons, pins, ties, insignia that make a statement. No political commentary, no campaign buttons. It's election day. It seems a good day to remind ourselves of that. Not a place to make a statement. I mean, if you put a political button on your lapel, you're going to piss off half the people on the jury statistically. So just don't do it. And above all, professionalism is really the key. Behave like a professional who inspires confidence and trust and credibility. I like to tell clients that if you're testifying as an EMS professional, you walk into that courtroom with a high degree of respect from the jury. You are in a profession that the public respects. That's particularly true since 9/11. What I tell clients is don't give that away in pieces by compromising your credibility, letting your temper get the best of you, using slang, using inappropriate lingo, using curse words. Every little thing like that gives away a piece of the credibility that we have just by walking in the courtroom. Speak in a loud, clear, confident voice. If we're mousy and they can't hear us, we're not believable. That starts from the very beginning. First impressions. You're sworn in. Do you swear to tell the truth, the whole truth? I do. Let's roll. Okay, leave out the let's roll, but you get an idea of what I'm saying. Confidence from day one, from word one. Your posture matters. This is all the stuff your grandmother told you about, right? Don't slouch. Don't fidget. Don't look away. Don't look around. Don't look distracted. Keep your hands down at your lap. We don't, all the gesturing with hands and all that kind of stuff. Just keep it, controlled. Don't put your hands up by your mouth. Sit up straight. All the things that your grandmother taught you. Make eye contact. Now, if you're in a deposition, sitting in a conference room and lawyers are asking you questions across the table, look at them. If you're in trial, if you're in a courtroom with jurors, I always tell my clients, look at the jury. It's our human instinct to want to look at the person who's asking us questions, the lawyer, but they're not the one you're trying to convince. It's the jury you're trying to convince. I make a habit of positioning myself between the witness and the jury. So I'm standing near the jury, so they have to look at me. They're looking in my direction, and hopefully then they're going to look at the jury, and I'll remind them of that by where I position myself in a courtroom. Not all lawyers will do that, but remember it's the jurors you're trying to persuade. Look at them. I love this line from the movie Ocean's 11. I use a lot of movie references here. There's a great scene where Matt Damon's character is going to go and talk to the owner of the casino, and Brad Pitt's character is preparing him for that, and he's pretending to be a member of the Nevada Gaming Commission. And he's like, if you look up, you don't know. If you look down, you're lying. And he's trying to throw all these pieces of advice at him. But, largely that's true. Sort of that, oh, look up. Gee, I don't know. It's kind of just naturally what we do. So when we look around and we look, elsewhere, people can question our sincerity. Now, sometimes, I know this will be a galloping shock to you, lawyers aren't always clear in the questions they ask. And sometimes they're deliberately trying to trip you up, especially if they're on the other side. If you are not clear of the question, do not embark on answering it. If you're not clear, say, I'm not clear. I don't understand what you're asking. I'm sorry, can you repeat that? I'm sorry, your question isn't clear. I'm sorry, I don't understand. Do not attempt to answer a question unless you are certain that you understand what's being asked. If honestly the answer is, I don't know, I don't remember, then say that. It's okay to say I don't know or I don't recall. I mean, if that is honestly the answer. The worst thing you can do is guess because you think that's what the lawyer wants you to say. If you don't know the answer to the question or you don't recall it, then say that. Now, if you make a mistake in your testimony under oath, mistakes are okay. Lying is not okay. If you make a mistake, it's okay to go back and say, I'm sorry, I was just thinking about something I said a couple of questions ago, and I think I misspoke. You asked me blah, 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 and I said, the following. I think I misspoke. What I meant to say was, it's perfectly okay to do that. In fact, in a deposition, the witnesses are typically given an opportunity to read their testimony once it's transcribed and make corrections before it's final. A lot of times lawyers will gloss that right over at the beginning of the deposition. They'll say, yeah, we waive usual stipulations, we waive reading and signing. Do not let your lawyer waive that right. You want the ability to review your deposition before it becomes your final testimony because you might have misspoken, the court reporter might have taken something down incorrectly. You have a final opportunity to review a deposition. But you can always correct your testimony while you're still giving the deposition or when you're under oath. Sometimes lawyers ask what we call compound questions. That's where they try to bury two questions in one. And the problem is, if you say yes, you might be saying yes to both parts of the question when you didn't intend to. For example, did you determine the point of impact from conversations with witnesses and from physical marks such as debris in the road? If I say yes, that implies I talked to witnesses and looked at the physical marks. There's three different things that I determined the point of impact. I'm not sure which I'm saying yes to, if I'm saying yes to all of them or if I'm saying yes to part of it. Now, usually the opposing lawyer is going to object to that. Objection, Your Honor, compound question. And the judge will direct that the lawyer rephrase it. But that's not always the case. If there's no objection, you can ask that be rephrased or broken into parts. Okay, so make sure that is clear. Now, this is probably, Dr. Lee and I were talking before the webinar, and I said to him that this is probably the thing that I find the most difficulty with in EMS professionals that I put on a witness stand, and that is to limit your answers only to the questions you are asked. And as EMS professionals, a lot of us teach and we do other things, and we tend to want to be teachers when we're testifying. We want to prove our knowledge. We want to establish our credibility. We want to show people we know what we're doing. There are other times and other places to do that, ladies and gentlemen. When you're being questioned under oath is not the time to do that. I tell my witnesses, listen carefully to the question you're being asked and answer only that question, no more, no less, then shut up, then stop talking. And I give my clients an example that says, for example, if somebody asks you, are you wearing a watch? Yeah, it's 3:30. No, that's not the answer. The answer to the question, are you wearing a watch, is yes or no. If somebody wants to know what time it is, That's another question they need to ask you, okay? Listen carefully to the question, answer only what's asked, and then stop talking. Lawyers have all kinds of tricks to try to get you to keep asking or keep talking. We tend to sit there. You finish your answer, then we just fold our arms and scowl at you without saying a word. We stare at you. And a lot of human reaction is, well, he wants me to keep talking. I better keep talking. I tell my clients, just sit there and stare back, okay? Take your sip of your water, look at your watch, do whatever, right? Do your nails, I don't care. If you've answered the question, stop talking, sit there and stare back. If they're playing those games, wait till they ask the next question. Now, there are different types of questions, and depending who is asking you the questions, you need to understand those different types of questions. If a friendly party, a friendly lawyer, your lawyer, is asking you questions, that's what we call direct examination. That's when they want to establish your credibility, put your credentials, your background, your education, your experience. Those questions on direct examination are going to be open-ended. The goal is to allow the witness to fully explain the facts and build credibility. So, Mr. Wolfberg, tell us a little bit about your background. Well, I was born in a log cabin in 1826, and so it's open-ended kinds of questions. Now, cross-examination is when the opposing party is trying to poke holes in your story. So those questions are going to be asked only really in what we call leading fashion. Those are leading questions, which means only a yes or no answer is possible. Okay? Isn't it a fact that when you went on duty, you had not slept for the last 36 hours? Right? The question is a yes or no question. It's going to be a question that is leading. It's permitted. In fact, it's expected that opposing counsel on cross-examination will ask leading questions. And usually, the answer can only be yes or no. If you start trying to explain, the lawyer is going to be able to shut you down. Now, responses in testimony need to be verbal. If you nod your head or shake your head, court reporters can't write that down. Grunts and groans can't be transcribed. All responses have to be verbal. Now, you may be testifying and a lawyer may make an objection. The question was inappropriate or is illegal for some reason. If you hear the words, "I object," "Your Honor, I object," whatever those words are, stop talking until that objection is resolved by the judge. I always advise my clients to avoid speaking in absolutes. If the words "I always" or "I never" are about to come out of your mouth, think really carefully about what's going to come next, right? Because those absolutes may come back to haunt you. Well, my usual practice is to do X, Y, or Z. Typically, I try to do X, Y, or Z. It gives you wiggle room as compared to speaking in absolutes. This is a tough one too. When attorneys are trying to push your button, impair your credibility, undermine your testimony, they're going to deliberately try to push your buttons. It is easier said than done, I know, but try to maintain a calm and businesslike, professional demeanor at all times, even when the opposing party is trying to pick apart your story. And this also goes back to grandmotherly advice. Being well rested. None of us are at our best when we're tired. And when we have a good night's rest before we're testifying, we can think, we're more sharp, we can respond to those things more appropriately. Don't let our tempers get the best of us when we're testifying. Let the jurors hate the lawyers, not you. Okay? Let the lawyer get aggressive. Let the jurors hate the lawyer. You maintain a calm, respectful, professional demeanor and a business-like attitude. Let the jurors save their amity for the lawyers and not for you, the witness. If it's necessary for you to address the judge, which is usually not the case for the witnesses, but if it is, Your Honor or Judge are generally the appropriate ways to do that. Hey, guy in the robe, I would advise against. Speaking of, we all have senses of humor in EMS. Sometimes our senses of humor are a little bit off color and off kilter compared to the rest of the general public. We use words that the public would not appreciate, but among our own kind, we tend to refer to patients and road pizza for trauma and crispy critters for burns and it may be great when we're sitting around the station among our own kind, but in a courtroom, it's not the time or place to be lighthearted about it. Don't trivialize it. It may be a joke to you, but it's not a joke to the judge, it's not a joke to the jury, and it is definitely not a joke to the parties involved. So avoid jokes, avoid those lighthearted comments as a general rule. So with that, I'd like to leave a little time for questions and discussion, but I do want to urge that if you're on Facebook, you can find Paige Wolfberg and Worth on Facebook. And Dr. Lee was kind enough to mention our website. Here is the web address. It's pwwemslaw.com. And there is a lot of content on there, articles, free stuff, anything free from a lawyer. It's hard to believe, but we put a lot on there that's informational, a lot of resources. We have what we call the EMS Law Library. And you can sign up for emails that we send out when some new cases and things are issued and new developments. So if you want to sign up to receive those, that's absolutely free, and we would certainly welcome you to do that, or just browse the site for any content that you may find interesting. So with that, I would like to turn it back to Dr. Lee to take us into Q&A and moderate any discussion. And thank you all for your kind attention.
Mr. Wolfberg, that was just excellent. I've seen a number of presentations by attorneys to EMS, and frankly, I've been probably critical more often than not of those. I think that presentation was superb, and I will mention again that we will have it on our website if anybody wants to review it. And again, you can answer some questions and get some. I think we're going to give one CEU for this lecture. I have some questions that are lined up. I had a few come in during your talk. So let me start with this one. I think Ian German asked I think a practical question. He's from Sunrise EMS, and that had to do with his deposition, or a deposition. And when do you get a chance to review that? And what if you made a mistake in the deposition? How do you clean that up?
Yeah, usually a few weeks after the deposition testimony, and thanks for the question, by the way. Usually a few weeks afterward, the court reporter will transcribe it, and they'll send the transcription usually to your lawyer, or if you're not represented, they'll send it right to you. You then get the right to review that. Now, some states and even some counties are different. Some courts may say anything you said you can change and correct up until the time you sign that deposition. Others say you can only correct typos and mistakes that are made. So some courts will allow you to actually change your testimony if it's not what you wanted to say. Others will allow you only to make clerical corrections. That varies by court. They usually attach a sheet to your deposition for corrections. You simply write on page 26 on line 14, I meant to say this, but what I said was this, and that's my testimony. And then you sign that correction sheet, and then that becomes your final testimony. So you are allowed to make corrections to depositions. When you're in trial in a court, not so much, but in a deposition, you're given an opportunity. Again, don't let your lawyer waive that right. A lot of lawyers just routinely, we'll waive reading and signing, Your Honor, or to the other party. Don't waive that. You want the right to review your testimony, your deposition, before it's final.
Yeah, after many of my depositions, the question is always asked, would you like to read? And that's where we get the chance to agree to review it and or to waive it. And I think that's a good point, not to allow it to be waived. Is that correct?
It is, because you might have said the right thing, but the court reporter might have heard it wrong. Especially if you're using medical terminology and clinical terms. Don't expect the court reporter knows the difference between a tibia and a fibula, or a cranium for that matter. So I advise my clients not to waive their right to read the deposition. If nothing else, not that you misspoke, but the court reporter might not have gotten it right.
Okay, I have another question. Came in from, I think it was Julie Downey from Davie Fire Rescue. Julie wanted to understand what you should do if you get a subpoena where your sense of it is that you're being subpoenaed as a material witness, and it says show up at, X time, X location, and that because of your job and your schedule and your responsibilities, that's a conflict. How should you manage that?
Well, as I recommend, make sure your agency's aware of the subpoena. And if you've been subpoenaed related to a call, it's part of your job. And generally, under the law, your employer is required to compensate you in most cases for the time you spend having your deposition taken. So you need to let your employer know about it. You can't just show up at a deposition and then submit your hours and expect to get paid. They need to know about that. But again, as I said earlier, the subpoena might have flaws in it, and the subpoena might be legally infirm, as we call it. So bring it to the attention of your employer. Make sure they know about it, because their legal counsel might be able to object to the subpoena. You need to be covered so you can get paid for your time in giving your deposition, and you need to make sure that any documents or information you release is done consistently with HIPAA. So your privacy officer needs to know about it. So take the subpoena to your agency and make sure they have an opportunity to work with you to respond to it.
I would like to comment, maybe you can expand on this. In subpoenas and a number of incidents, I am surprised that many times I have to remind folks that they should talk to their city risk manager, and so that seems to be the route to get these things under control. Would you comment on that?
Sure. Yeah. I mean, whoever your department has designated as that person, it might be a risk manager, might be city legal counsel, might be they might want it to go through your command structure, your supervisor, or your chief. But yeah, that would typically be where most of those would end up, either privacy officer, risk manager, or even city legal. They can look at that. The thing I tell clients is they're surprised about this, but subpoenas people think are issued by courts. In most cases, they're not. Lawyers go to the court clerk's office, and they usually charge you like $2 a subpoena or something with the little gold seal on it, and you buy 10 or 20 of them at once, and you just issue them as you think you need them. Some lawyer just decided to send you a subpoena. It doesn't mean the lawyer always has a right to the information they're asking. So that's why you got to go to whoever that is your city has designated, if it's a risk manager or a city attorney, so they can review it, because the subpoena might be flawed.
Good. Let me ask you from Louis Villar, captain at Margate Fire Rescue. Louis pointed out that it's not uncommon that the paramedics will jot down data, if you will, notes on everything from a scrap sheet of paper to their glove, and then ultimately transpose that to the record. And his question has to do with, is that material, does that need to be kept or not as part of the medical record?
Good question, Louis. Usually no, it doesn't have to be. As long as you have then taken all the information from your scrap sheet, your quick ticket or whatever you call it, and put it on, it's in the final patient care report. Typically those notes do not need to be retained. Your agency we recommend agencies have a policy on that. What happens to the notes, the scrap papers, the quick sheets, whatever you call them. Our recommendation is that they not be kept. And one other thing I would recommend is that the personnel individually not keep those. I've talked to people who said, I make a copy of every note and every PCR, in fact, and I take it home and I have my own file. You don't get to do that. That's the protected health information of your agency. Those notes, if your agency's policy is to keep them, then your agency should keep them. But our recommendation is that those pre-notes, those pre-PCR notes, should be used to compile the PCR, and then they should be destroyed.
Good. Thank you. Another thing that happens is that it's not uncommon that the system will get a request for records. And of course, there's the medical record, if you will. But there may be an incident report that was filed because there was a breach, a failure of equipment, a breach of protocol, something of that sort. How do you handle that? Do you have to provide all the records? Are some protected and others aren't?
That's a great question, and it's a complicated answer. I'll just try to be as succinct about it as I can. we first and foremost is documentation. It's EMTs and medics need to know that when they're charting, that there's a line between what should go on a patient care report and what should go on a separate incident report. Anything that affects the care or treatment of or condition of the patient is patient care related and should go on a PCR. So if an piece of equipment malfunctions and it affects patient care, that may need to go on the PCR. If I sideswipe another car on the way back to the station after the call, that's not going to go on the PCR, and it shouldn't. It's a separate incident report. So first and foremost, a determination has to get made as to what should be kept on a PCR. You can't omit something that's material to patient care, even if it looks bad. Oh, we didn't have the proper intubation kit on board. Well, that doesn't look good, but it affects the care of the patient. Something that doesn't directly affect patient care would be on a separate incident report. Now, lawyers battle day in and day out about what's discoverable. Plaintiffs' lawyers are going to want your incident reports and your QA documents and your privileged and confidential notes and records of, peer review and all that stuff. Just because they ask for it doesn't mean they're entitled to it. When our clients, the EMS agency, gets those kinds of requests, the first thing we say is, well, get the records together, let us look at them, and if we believe those records contain privileged information, we're going to basically send a response back to the other lawyer that says, nope, not so much. Here's the stuff that you are entitled to, but we object to the production of the rest of it because we believe it's privileged. Then the lawyers will battle over that, and eventually the other lawyer is going to go file a motion with the court. The judge is going to say, let me look at it, and I'll decide whether or not it's discoverable. So if you're trying to make a case that your peer review, your QA, your incident reports are privileged, I tell people, it sounds elementary, but buy yourself a big red stamp and literally stamp those documents, peer review, privileged and confidential, because if the dispute ultimately goes to a judge, they're human beings too. And if they look at that record and say, oh, well, this is stamped privileged, it's protected, it's, keep it physically separate from your PCRs, don't store it with your patient records, the more you treat it and respect it as privileged and confidential, the more a judge is likely to do that too. So physically separate incident and QA and peer review stuff from patient care reports, mark it as such, treat it as such, and that'll increase the odds that a judge will protect it and not order that it be discovered. It's a complicated question as to what's discoverable. There's a different standard for what we call discoverability than what the standard is for admissibility. So even if I have to turn it over to the other side, they may not be able to use it in court because it may not be admissible. So the standards for what's discoverable and what's admissible in court are actually different standards. So even if the judge tells us we have to turn it over, it's not the end of the battle because I can make an objection at the time of trial too.
That was a great question. I really liked that question, and I really liked your answer. I can actually hear the wheels turning with all of our leadership out there as they begin to think about getting the stamp and separating this out, probably doing a better job. That's always been a little challenging, I think, as a medical director too. What can we document in terms of quality, et cetera, et cetera. So thank you for that. I appreciate it.
You're welcome. If I may just add, because something you just said triggered another thought here, and that is, I've heard a lot, and I don't think this is the case here at all because you guys are so progressive and forward-thinking, but, a lot of folks have said, gee, the more I write down, the more that can come back to hurt me, so I'm not going to write things down. When we sit down and have a QA meeting and do, honest, thoughtful, forthright peer review, yeah, we're creating documents that, if we're candidly acknowledging our flaws, could, if discovered, be used against us. But the risks of not doing that QA, the risks of not candidly addressing our flaws and correcting them, are going to make you 10 times more likely to be sued than if we don't do it. So the fear of getting sued is not a good reason not to do that thorough and detailed and honest QA.
Let's talk about that just for a second. We have a few more minutes, about 8 more minutes looks like to me, but let's talk about that. It's not uncommon as a medical director that I will hear a paramedic voice his concern over his liability and that he's doing it to protect himself and so on and so forth. And, I always maybe too glibly comment that, and I'm not sure this is the correct answer, but essentially that he doesn't have the liability, that the city will be the one paying the tab, and or perhaps me, where I have an individual policy for malpractice, which has never happened. But nonetheless, can you comment on the liability of the individual paramedic that is working for a government agency?
Sure. Um, I've never, ever in my experience as an attorney had a case where an EMT or paramedic as an individual had any out-of-pocket liability where they had to pay money personally for a medical malpractice case. Now, we've had clients that have broken the law and committed crimes, for example, that have, falsified records and done things like that. That's different. If you break the law, you suffer the consequences, right? You don't get to break the law. But for simple cases of medical malpractice and making mistakes, mistakes happen. That's what we call malpractice. I've never had a case where the personal assets of an EMT or paramedic have been paid to a plaintiff. Now, that said, if you are concerned about your personal exposure, you can usually add personal liability protection to your homeowners or renters policies for a pretty cheap amount. NAEMT and other national organizations make personal liability insurance available. You can often see those ads in the EMS and GEMS magazines. So there are those things available. If you've got assets that you want to protect, you may want to look into that personal liability insurance. But I've never seen a case where an EMT or paramedic has had to pay out of pocket. Your agency has insurance coverage. If you work for a public agency, city, county, etc., there may even be immunity against individual liability and what we call sovereign immunity or local government immunity that protects you even further. So I've never seen a case where there's been personal out-of-pocket liability, but if it's a concern that you have, there are different types of insurance coverage, typically personal liability policies that you can get for that purpose. If you're also concerned, you can check with your agency and see what the extent of their coverage is, see what kinds of policies they have, and determine if you're satisfied with the extent of their coverage.